Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.
People v. Cesar Garcia. Decided May 24, 2022. Memorandum. The order of the appellate term should be affirmed. Defendant was originally charged with public lewdness, 2 counts of forcible touching, and 2 counts of sexual abuse in the 3rd degree after police officers observed him masturbating on a subway platform and pressing himself against 2 women on a subway car. The people thereafter filed a prosecutor's information reducing the 2 Class A misdemeanor charges of forcible touching to attempted forcible touching, so that the top charges against defendant were Class B misdemeanors, obviating his right to a jury trial under state statute. See CPL 340.40. After a bench trial, defendant was convicted of public lewdness and acquitted of all other charges. The appellate term affirmed the conviction. Applying our holding in People v. Suazo decided after defendant's conviction, the court held that defendant had not met his burden of establishing deportability based on the crimes for which he was tried. While the appellate term first improperly conducted the deportability analysis based only on the crime of conviction, that court went on to correctly analyze defendant's deportability based on all the charges he faced. See Suazo. It remained, however, the defendant's burden to overcome the presumption that the crime charged is petty and establish a Sixth Amendment right to a jury trial. We agree with the appellate term that here, defendant's conclusory allegation that he was deportable if convicted, on any of the charged B misdemeanors, supported by a bare citation to, under which an alien is deportable if, convicted of 2 or more crimes involving moral turpitude, not arising out of a single scheme of criminal misconduct, was insufficient to establish his right to a jury trial. In Suazo, by contrast, defendant's assertion that the possibility of deportation upon conviction rendered the Class B misdemeanors sufficiently serious to mandate a jury trial under the Sixth Amendment, met his burden to show deportability because it was clear from the face of the accusatory instrument, that at least one of the charges lodged against him qualified as a deportable offense. Our dissenting colleague asserts that defendant's charges required no greater analysis or piecing together of federal law than that in Suazo. But the insufficiency of defendant's assertion is quite ably demonstrated by the dissent's cursory review of this issue, which spans pages of text and includes a 34-line footnote analyzing federal immigration law. Holding this defendant to the standard we articulated in Suazo, as we do and the appellate term did below, does not create an ambiguous and heightened burden, nor does it violate the principle of stare decisis. Order affirmed. In a memorandum, Chief Judge DiFiore and Judges Garcia, Canatero, Troutman and Winslow concur. Judge Wilson dissents in an opinion, in which Judge Rivera concurs. Judge Singas took no part. Decided May 24, 2022.
Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.